Hey everybody, it's Yasha Saba from Sky Unlimited Legal Advisory, and this is this week's Ask Me Anything, where you can send any questions you have related to your business or your estate plan, and asset protection, and I'll try my best to answer them anonymously so that we can share with the public and spread education and you can gain some more knowledge. So sorry for the messed up hair and sorry for the delay. I just landed in beautiful San Diego off of my flight and I had no time to get home and then come out to you guys. So here we go. Is there some type of document that can be filed for the return of equity that my son has been given? Much has been given to him by me and his dad: real estate, automobiles, cash, and farmland adjoining my current farm to help him and his wife get off to a good start. Wow. If my parents was giving me all of that, I would be a very happy boy. This son of yours is very spoiled, in my opinion. Sorry, but not sorry. But now this is not happening. What do you mean? He now has the small tract of farmland up for sale. He's currently going through a divorce and ran his wife off so he could take up with a married lady. You're hearing the drama, people. Wow. Is there any legal way to stop such activity too? Okay, first step, the moment you gift something to somebody, you cannot take it back. When it's gifted to them, it belongs to them. The only way you can ever take that gift back is if you have some kind of agreement that goes with the gift, and you usually see this in the nonprofit world. A donor gives a nonprofit some money, and then they say to that nonprofit, this is what you use the money for, and if you don't use it for whatever we gave it originally to you, then you have to give it back. Same thing can happen with a gift, but it requires a contract. Are you going to create a contract with your kids when you give them property, assets, automobiles? Not really. So the hard part there is now it's taken. So with that being said, can your son do whatever he wants with the assets you gave him? Yes, absolutely. If he wants to sell the farmland, he's selling the farmland, and there's nothing you can do about that. You can't reverse it. I feel so bad that he's driven off his own wife and he's trying to go after a married lady. Whatever the drama is there, I don't like to judge. I like to question, of course, but that's the hard part with this. What you can do, though, is if you don't like what has happened, if you don't like what your son has been doing, you can write this up in your estate plan. Say, my son gets nothing upon my death, so none of your remaining assets, because we believe we've given him everything that he deserves in life. This is something that you should seriously consider. Maybe even disinherit your son if you're really upset with him and his actions, right? That way your son gets absolutely nothing from your estate plan. So that's the reactive measure you can take. There's really no reverse that you can do. How do you stop your son from running off with a married woman? There's nothing you can do there too. Really, like in life, there's no control that you can have over people. The only control you can make happen is how people receive after you've had your time here on earth, right? And you can dictate what they do with what they receive. But when you give during your lifetime, you kind of are giving up all control from there. Next question. I am a trustee. I incurred $10,000 in expenses. I understand that I will be reimbursed for this, but I am also an heir. So this person's the trustee and also an heir of the estate. As an heir, am I also responsible for a portion of these fees as well, as I am receiving a percentage? First off, heirs are never responsible for paying for expenses and costs. All of that comes out of the estate itself. So if you're a trustee and you're managing assets in the trust and you've racked up $10,000 worth of expenses, that's supposed to come out of the assets of the trust. So the assets inside of the trust are what's supposed to pay the expenses. If there's no more assets in the trust, then you probably can't get paid back. You can go back to the heirs and ask them for reimbursements, but they don't have a legal responsibility to pay you back. Remember, when your parents die or when you die, your family or you as your parents' child are not responsible to your parents' creditors, and your family is not responsible to your creditors only unless they've co-signed whatever loan or debt that you've had. So the same concept kind of applies towards trust. So as trustee, yes, you will get reimbursed for your expenses, but who's going to pay you for that reimbursement? It's going to be the trust. Now, as an heir, I know that there's a lot of things you're doing to manage the assets, and obviously there's benefits towards you as an heir to manage the assets that's in a way that's favorable towards you. Be very careful if you have other family members, other beneficiaries, other heirs that are also receiving under this trust. Just because you're an heir, there might be a little more scrutiny to what you're doing. So make sure you're doing everything by the book. And also read the terms of the trust. It dictates how you get paid. It dictates your fiduciary responsibility. It also dictates whether you can engage in acts of self-dealing, especially if there are other beneficiaries involved. So if the trust is silent on that, then yeah, generally speaking, you can't do any self-dealing. So you have to make sure you're not favoring yourself whenever you're making distributions or structuring the assets, selling off assets. And you also want to make sure if you've got $10,000 racked up in expenses, I hope you've been accounting for those and saving receipts. Because if you try to reimburse yourself for that $10,000 and other family members don't like what you're doing, you might be in a little bit of trouble there. Okay? Next question. Can a personal representative, when we talk about personal representatives, usually this is the person that's the executor of the estate or the person in charge of a will. So can a personal representative accept a home offer of a will that is part of 3 kids? Okay, another question with bad grammar. That's okay, we'll figure it out. He is one of the kids and the offer is $20,000 under market value. This is a very good question. Okay, so similar to the trustee being an heir, we have the same situation here. We have a personal representative, someone that's in charge of the estate with a will. Obviously, there's no trust. Otherwise, they would say the trustee. And what's happening is he's in charge of handling the assets, managing the whole entire probate, and making sure everything gets passed down the way it's supposed to in accordance with the will. And it sounds like they have real estate in the estate, and he wants to sell the home. And it sounds like the offer to sell the home is $20,000 under market value. And he is one of the kids, and so I don't know what his place is with this offer. Who's making the offer, for instance? Is it him? Is it another family member? Is it his friend? Or is he just trying to sell the assets really quick, so he doesn't care how much it is, he just wants to liquidate really quick and get it done with? Here's something to keep in mind. When you have a will, or if you don't have a will, it goes through probate. All wills go through probate, no matter what. Only a judge can authenticate a will. So when a judge gets involved, even though the will says you are the executor, you're in charge, and you want to liquidate the home so the 3 kids can have the money, if you have, each law has different states on how this is handled. Here in California, the judge has to approve the sale of the home. So if you've got an offer and it's $20,000 under market value and you take that to a judge, and the judge sees here in California, beautiful San Diego, we have home prices going up in value, then that might not be a kosher thing with the judge. Think about it. The judge might say, why is this under market value when all the prices around in this area are actually going up? This doesn't make sense, right? But if nobody's prejudiced by it, meaning nobody's complaining and everyone's saying, judge, just let it pass, a judge is probably going to let it slide. Because when the beneficiaries don't care, why would a judge waste his time caring? His or her time caring, right? So something to keep in mind. But if you are also a beneficiary person asking this question and you have concerns, bring it up with the judge. And the judge will say to the personal representative as well as the real estate agent, go ahead and wait for more offers because this doesn't make sense, right? But as you can see, there's no right or wrong answer. It's all on the circumstances, what the family wants, and what makes sense towards the regular market on what's happening. All right, everybody, I'm very disheveled. I'm tired. I'm ready to go on vacation for Valentine's Day with the wife. We're going to go to Disneyland later today. So I hope you all have a wonderful weekend. Have a happy Valentine's. I love you all, and I will see you next week. Take care.